Someone make it make sense.
Probably a couple.
Hello, everybody. We are back for more Karen Reed. We've got another onslaught of motions in limine and other related motions. Similar motions are coming fast and furious. And yeah, so we're going to go through as many as we can. And then this should automatically redirect you guys into the next stream. Now, the next stream is going to be the recently, as of I think yesterday, released original video, bridge guy video for Delphi. So we're going to take a look at that. I may also have another stream this afternoon for the latest documents out of Idaho. And then tonight, I'm also planning on going through that Lori Vallow hearing where she's representing herself pro se and has to argue motions in limine. Go figure, right? Motions in limine all over the place in these cases. It's kind of insane. So I hope you guys are doing well. Good morning, Candace. Welcome. And as some of you guys may have heard, I'm still working on getting that trivia night ready for members only, but I think I'm about halfway there. I don't know how many questions we will need. So I'm probably going to have like more than enough questions. I think right now I have like 30 something questions. But yeah, so we will have that coming up soon. And for those of you guys who are following the ORCID members only videos, I have another members only ORCID video that should post today. I actually have it done. I just have to upload it. So we have that to look forward to as well. So we may end up with 4 live streams today, maybe 5, just kind of depends. So, okay, but let's jump right on in here. So this is the first of the documents we're taking a look at today. So Commonwealth's motion for attorney conducted an individual voir dire of potential jurors and proposed jury questionnaire. Now comes the Commonwealth. Please don't be doing that, Commonwealth. Respectfully moves this court to allow the Commonwealth to submit a written questionnaire to prospective jurors and allow for attorney conducted voir dire and individual questioning of each prospective juror to ensure that each person called as a juror stands indifferent to this case. Now, what's interesting, so there's a motion filed by both parties for voir dire of the jurors. Now, what'll be interesting to see is what the differences are, right? So under Superior Court Rule 6, the trial judge should consider some individual voir dire in all cases to determine whether any juror has an impediment concerning hearing, language, or visual ability, mental health, or comprehension, and to determine whether a reasonable accommodation would enable the juror to serve. 2, address any private or embarrassing information not disclosed in public portions of the voir dire. 3, identify any other impediment to jury service that the trial judge and parties might not observe without personal contact with the juror. Now, one thing I will say, some of you guys may know that the very first case that I watched gavel to gavel, because I didn't know that it was a thing you could even do, was during George Floyd. There's the Derek Chauvin trial. And that was before I'd ever heard of LawTube. And I don't even think anyone was covering it anyway. So I watched that entire trial gavel to gavel. It was during COVID, right? So I watched the entire thing gavel to gavel without anybody explaining stuff or whatever. But what was interesting is like the way that whole thing started was they showed the entire voir dire process. And again, I didn't have anybody explaining things, but I still remember how interesting I found that voir dire because of this exact reason here with number, where is it? Number 2, Roman numeral number 2, where if there was something that was coming up that somebody maybe had been a victim of some sort of essay or whatever, right? That they would cut the cameras and then question them so that it was private. I think they also asked some questions without the other jurors around as well. But anyway, I just wanted to say that I saw that as an example, and I thought that was really a good way to handle it and very interesting to witness that process. The voir dire process was like 2 weeks for that trial, if I remember. And that was already the narrowed down pool. From what I recall. Anyway, okay, so individual voir dire outside the presence of hearing of other members of the jury pool. There it is. Increases the amount of information obtained from a prospective juror. Yeah, exactly. Thereby assisting the court and parties to accurately assess whether the prospective jurors in this case are free from bias. And one thing I'll note too, this came up in it might have been Idaho, one of the documents talking about jurors. But one thing that's interesting is when the jurors are around other jurors and they're asked questions like, can you set aside all your bias and be fair and impartial? And they're more likely to say yes, even if the answer might be no, or even if they're unsure, because of their peers. People don't want to be judged poorly by their peers, right? Like, it's, in other words, it's one of those things where it's like, it's kind of like the group is going to all say certain things. And so they don't want to go against that. You know, a lot of people, some people might not want to serve on a jury, and then they might say, no, I can't be, right? But in other words, people who might be on the fence, they might be more likely to say, yep, I can be. Whereas if they're questioned individually, you might actually get a different answer from them. So just throwing that in there as well. So the Commonwealth seeks to question prospective jurors about what is specifically referenced in their confidential juror questionnaire to determine whether the juror stands indifferent to this case. Should be unbiased, but indifferent's an interesting word. So, okay, so next up, defendant's motion in limine to exclude the serum, plasma, ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So moves the court to exclude evidence of a serum, plasma, ethanol concentration test performed 9:08 a.m. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police. As grounds for this motion, Ms. Reed states that, as acknowledged by MSP forensic scientist in his report, quote, the ethanol result used in the reports was provided by an external party. The testing to obtain the ethanol result was not performed at the MSP State Crime Laboratory, and therefore do not fall under the laboratory scope of accreditation. Now, I will say this much. I understand why they're making this motion, but I would say I would trust a third party more than the Massachusetts State Police crime lab, right? But anyway, and the thing is that this is going to get denied. I mean, because this is just going to get denied. But we'll go through some of this anyway. They're saying it would be unreliable. So the factual background, Ms. Reed tested negative for any drugs. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 milligrams per deciliter. Using the value from the test conducted by the hospital without ever having applied for a warrant themselves to test Ms. Reed's blood, well, that's a whole other issue, right? Massachusetts State Police performed a conversion of the reported 93 milligrams per deciliter to get a blood ethanol concentration ranging from 0.078 to 0.083. So then this is where you get to the retrograde extrapolation, right? Using that conversion, Mr. Roberts then conducted a retrograde extrapolation. And both reports, he explicitly notes that the serum plasma ethanol concentration obtained was not performed at the Massachusetts State Police Crime Lab. Per a new report dated October 10th, 2024, on another new report post-first trial, go figure, authored by forensic scientist Hannah Knowles, the new serum plasma. Oh, that's interesting. Okay, so hold on. So it's different. Let's see. So now it says 0.078, 0.082. What was it before? 0.078 to 0.083. So it's actually a smaller range. Interesting. Moreover, in Knowles' report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45 a.m., the time of the alleged incident, in an attempt to account for uncertainties associated with the drinking history of the subject prior to the time of time interval. Her calculations determined that Ms. Reed's BAC could have been between 0.14 and 0.28. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, indicating the subject had consumed no ethanol half an hour to 1.5 hours prior to the time interval. What it doesn't say is the time allowance in the first trial, and I don't remember what it was. They're saying the interval was 8.5 hours here. Now it says with an additional 2-hour allowance. Does that mean it's 8.5 plus 2, or does that include the 2 hours? And how is this different from the first trial? Maybe they'll talk about it, but they're getting into the argument. So we'll see, because I don't know how this is, I don't know what to make of this without having the other time intervals from the first trial to compare it to. But it sounds like it's different. So Okay, argument. Because both the initial serum plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, the blood test should be excluded. Retrograde extrapolation is a mathematical calculation to estimate a person's blood alcohol level at a particular point in time by working backward. Which of course is, you can see that there's problems with that, right? Because everybody is going to process alcohol differently and there's all these different factors, right? But anyway, breathalyzer test results are generally admissible without the need for retrograde extrapolation, without the need for expert testimony when taken within a reasonable time after the operation of a vehicle. Oh, wait. Okay, now there's a footnote here. This range differs from the range testified to by the forensic scientist used by the Commonwealth at the first trial, who indicated the range would have been between 0.13 and 0.29. Okay, let's go back up. So that's still not giving us a difference in the time interval, but at least that's something. So what is it? 0.13 and 0.29. So now it's between 0.14 and 0.28. So the max is lower, but the min is higher in terms of what this new person found in the new report from October of 2024. Okay, so where the Commonwealth is proceeding under an imperitability theory, and a test is administered outside of the 3-hour window necessitating retrograde extrapolation, expert testimony is required. Just last year, the Supreme Judicial Court addressed the issue of a defendant's consent to a blood test in a prosecution for simple and aggravated forms of OUI in comparison cases. Accordingly, whether Ms. Reed consented to the alcohol blood test or not is not at issue here. What is at issue, however, is that the parties lack essential information about how Good Samaritan Hospital drew and tested Ms. Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so they can themselves test a defendant's blood through a certified analyst. While these requirements pertain only to analysts working for the state police and not to the hospital personnel, they are in a place to ensure for that blood testing for ethanol undergoes a standardized, reliable, and repeatable procedure. Footnote 2. The admissibility of any given test result will be governed by the adherence to the policies and procedures, and while strict adherence may not be required, any variance will certainly affect the weight given the evidence and by the fact finder. Well, says certainly. I mean, there's no way to tell that for sure. Sometimes the jury ignores things. But anyway. Okay, the Massachusetts State Police utilize gas chromatography. Oh, we hear about this all the time in the Casey Anthony. Gas chromatography. Okay, the way that they say it in that trial, I thought it was all one word. It's not. It's 2 words. Interesting. Gas chromatography testing, footnote 3. Okay, that's not all that important there. Just gives us a link there. Okay. Rather than enzymatic immunoassay testing, which presumably was used by the hospital here. Okay. In the medical records provided under the chemistry section, there is an annotation regarding the drug testing, which states this report is intended for use in clinical monitoring and management of patients. It is not intended for use in employment-related drug testing or court-related proceedings. Oh, well, that's a problem, isn't it? Samples are not routinely tested for adulteration and are assumed to be within the normal physiological range, pH range of 5 through 8. The alcohol result is beneath this annotation. It is not clear whether this annotation applies only to the urine drug screen or to the alcohol result as well. Regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test was obtained, through what procedure, by whom, and what manner of testing was used, i.e. gas chromatography or enzymatic testing, the latter of which would yield a higher result. Absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face. In light of the fact that the MSP, Mr. Roberts and Ms. Knowles, each separately acknowledged in their respective reports that the serum plasma ethanol concentration test does not meet the accreditation standards for reliability, we know with certainty that the serum plasma ethanol concentration test was at very least conducted according to an entirely different scientific protocol. Okay. The defense does not take issue with the generally accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it was based. Without reliable foundational information about the initial serum plasma result, the serum plasma conversion to blood ethanol concentration and the retrograde extrapolation from the converted number is not reliable. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analyses by Mr. Roberts and or Ms. Knowles are accurate. Instead, 3 parties involved in this BAC test have expressly disclaimed the legal veracity of these results. The analysis of Miss Reed's blood was not, in fact, made, at least not completely, by the chemist who signed and swore the certificate, as is admitted in the reports by the MSP. In his testimony at trial, Mr. Roberts admitted that while the standard lab testing procedure is to conduct 2 separate tests within the laboratory, with Miss Reed's sample, he conducted no testing himself and merely assumed that the hospital's test was accurate. I remember that coming up in trial. Both of their analyses were conducted with data that they did not themselves collect. Mr. Roberts himself confirmed that an unreliable base for calculations like we have here is a serious problem for the reliability of the extrapolation result. Right, and I remember this, your starting blocks have to be good. You have to know the time in which the blood was drawn, the time of the incident. Right, okay. Moreover, the prior retrograde extrapolation was not in keeping with ANSI ASB best practices, and thus the new forensic scientist Hannah Knowles has now issued a report with a new and different range of BAC. Further, I was literally just going to say, this does indicate that there's issues, right? But keep reading, further underscoring the unreliability of the extrapolation in this case, right? The fact that they got different results. Accordingly, the serum plasma converts. So I take it back. Perhaps, I mean, I don't know, so, maybe not Judge Bev. I would love to be surprised and see her say, yeah, this is an issue. But anyway, I could see how a certain judge could say, yeah, no, that is a problem. Again, after the first trial, they crunched the numbers again, right? And got a different result. Yeah, that's problematic. And that does indicate the lack of reliability, right? Addressing the issue of pure evidentiary admissibility, the rule tells us that records kept by hospitals shall be admissible, may be admitted by the court in its discretion as evidence in the courts of the Commonwealth so far as such records relate to the treatment and medical history of such cases. Similarly, Commonwealth v. Dyer expands that medical records generated for evaluation and treatment purposes do not constitute testimonial evidence and may be admitted into evidence. Both the statute on point and seminal case on medical record admissibility pose conjunctive requirements, treatment and medical history and evaluation and treatment, right? Oh, I clicked too many times. Okay, here we go. No, wait. What did I do? Okay, yeah, I clicked. I thought it was never mind. I thought I was at the end of the page and I wasn't. Never mind. Okay, so evaluation and treatment. The common factor between the two authorities is treatment. Miss Reed's visit to Good Samaritan Medical Center and the records produced therefrom were explicitly not part of any process. Right, she wasn't treated for anything. Dyer found that when the defendant's blood was not connected to medical treatment, the Commonwealth's failure to meet the statutory requirements means that the documented hospital records themselves cannot be admitted under the hearsay exception. Wow. I mean, it makes you think, how was it admitted in the first trial then, right? I mean, that is pretty clear. That's from a Massachusetts case, right? Like this is... Therefore, Miss Reed's serum plasma ethanol concentration results should be excluded. Okay, next up. See what Judge Bev says. Okay, so now jury view. Yay! Defendant's motion in limine for view. Okay, to order that a jury view be taken of the alleged crime scene. You know, and as we know, they saw this last time, right? I'm sure this will be granted. Let's just see what else they have in here. So they request the court order a view of the house, the exterior of the Lexus. Ms. Reed further requests that the vehicle be towed to the public roadway, and it was last time. Finally, Ms. Reed requests that this honorable court permit Ms. Reed to attend the view. Now, I don't remember if she attended the view last time. Do you guys? If it were me, I would not, and I were like, if I were the defendant, I would not want to attend the view unless it was in a way that the jury couldn't see me. Like, I understand wanting to be there so you can see that there's no fuckery going on. However, the reason I'm saying that is because if she's like standing out there at the scene, you know that they're going to be looking at her and judging her emotions, right? I mean, that's what they're going to do. Or lack thereof, or whatever, right? Like I would imagine that a lot of jurors would probably put weight on how she reacts to the scene. And you know, if you're emotional, then some jurors might think that that's you're too emotional. And if you're not emotional enough, in other words, no matter what, they can always draw some negative conclusion from how you act. So I don't know. We'll see what else they say. But if it were me, I would want to be like, you know, in a vehicle with tinted windows or something where they couldn't see me, you know, whatever. So, okay. So the court may order a view by jury and panel. Right. Ms. Reed states that permitting the jury to view the scene, I mean, that's not a problem. They're going to view the scene. The question is going to be, what are they going to say about her? To me anyway. And obviously they did this last time, like we said. So allowing the jurors to inspect the vehicle. Yeah, I mean, okay, here we go. As with the decision whether to hold a view, the decision to allow a defendant to be present is within the trial judge's discretion. This is why I don't remember if she was there or not last time. Ms. Reed respectfully requests the court allow her to be present for the view, subject to any reasonable restrictions the court deems necessary. For the above reasons, Ms. Reed respectfully requests the court allow the motion for review. Okay, next up. Defendant's motion in limine to allow evidence of lack of bias. This is where we get into the ARCCA dudes. All righty. So to allow during her retrial, reference to the fact that it was the U.S. attorneys. So this is the big one, right? Because this is the thing. We heard how the jury understood this last time about the third party and all that, right? So to allow during her retrial, reference to the fact that it was the U.S. Attorney's Office that initially hired employees of ARCCA, namely Daniel Wolf and Dr. Andrew Rentschler, or sorry, just Andrew Rentschler, they're both PhD, and not the defense who commissioned these witnesses to perform testing and analysis of evidence related to this matter. And then where's the, okay, as grounds, therefore, Ms. Reed states that the retention by the U.S. Attorney's Office and not by the defense, and then here's a footnote. Ms. Reed wishes to clarify herein, in light of information sought by the court during recent motions, I'm sure this is going to get to the payment, recent motions, hearings, and disclosed by the defense as reciprocal discovery, that the defense was invoiced by and did pay ARCCA only following the conclusion of the first trial. Okay, so this answers a lot of the questions I had about what we were covered last time with the voir dire. So they asked to exclude the payment for voir dire for not just the ARCCA dudes, but also for Dr. Russell. And I was wondering, like, okay, so they want it to be like the payment just for the testimony. So they do want that to come forth. Now that makes sense. They have to agree to that if they want this to come out, right? Like that's reasonable. That's fair. That seems correct. So in other words, I would imagine that what they're also asking for here is the invoice, but that excluding, right, payment for voir dire because of that motion we covered last time. So invoice by and did pay ARCCA only following the conclusion of the trial. The defense intends to comply with its reciprocal discovery obligations regarding ARCCA's participation in the retrial, including its continuing duty to disclose should it acquire any additional discoverable information following the March 6th reciprocal discovery deadline. So, okay, so their retention by the U.S. Attorney's Office and not by the defense bears directly on their credibility, rebuts any contention by the Commonwealth of bias, will avoid causing the jury to unfairly speculate about the origins of their involvement, or otherwise prejudice Ms. Reed's constitutional right to due process and a fair trial. And then here's the background. They stated they were neither hired by the defense nor the Commonwealth. In fact, these two employees of ARCCA explicitly articulated they did not have contact with the defense or the Commonwealth regarding the specifics of their testing and did not consult with the defense or the Commonwealth. And Dr. Wolf himself clearly noted that ARCCA employees were hired by another agency not contacted in any way by the defense. This particular agency was left for the jury to speculate about, and at least one member did. The independence of these ARCCA employees, specifically Daniel Wolf and Andrew Rentschler, was reaffirmed during the motion hearings ahead of Ms. Reed's second trial. Footnote 2, see trial transcript. Nevertheless, these individuals who will serve as Ms. Reed's most critical exculpatory witnesses were indisputably engaged and hired by the U.S. Attorney's Office to conduct their independent review, analysis, and testing surrounding the singular question of whether Mr. O'Keefe died as a result of auto-pedestrian collision with Ms. Reed's SUV. These highly qualified experts have determined to a reasonable degree of scientific certainty that 1, Mr. O'Keefe's injuries and death did not result from being struck by Ms. Reed's SUV, and 2, the damage to Ms. Reed's SUV did not result from colliding with Mr. O'Keefe. In other words, the scientific data establishes that Ms. Reed did not strike Mr. O'Keefe with her vehicle. Yep. Both Dr. Wolf and Dr. Rentschler, two individuals who were not hired by the defense to perform their testing, testified to this highly relevant and exculpatory fact during Ms. Reed's first trial and during voir dire under oath and threat of perjury. Furthermore, the Commonwealth, by its own admission, has admitted that, quote, it's not the ARCCA witnesses that I have the issue with. Right. He said that so many times, y'all. He said it so many times. Breenan, right? Moreover, the Commonwealth stated that it doesn't care if the ARCCA witnesses testify at trial. I don't care about their opinions. I'd welcome ARCCA. Love it. Love it. Most recently, the Commonwealth communicated to this honorable court, or as DSN so astutely put it yesterday, barely honorable court, which I think I told him was being generous, that, quote, there's a murky relationship between the defense and the U.S. Attorney's Office relative to these ARCCA witnesses, and there is a very unclear relationship as we stand here right now between the history of the interaction between the defense and the ARCCA witnesses. We all heard that. The Commonwealth has additionally conceded that we still don't know the relationship between the defense and the ARCCA, not the ARCCA, sorry, ARCCA. We don't know about the impact it has on the first trial. The Commonwealth has provided no objection or legitimate legal basis for not disclosing in Ms. Reed's second trial that employees of ARCCA were hired by the U.S. Attorney's Office. In fact, the Commonwealth itself, and I will say, just to make a distinction to the first trial, it was a little bit different in the sense that this was kind of one of those last minute things where they were still being engaged by the U.S. Attorney's Office. It was really unclear as to how things were going to proceed. And the whole thing of like, well, the important thing is getting their testimony in, right? We'll deal with it after the fact. This is a little bit different in that now their engagement is complete. There's been plenty of time for the discovery to come through, like everything's out in the open about it. And in other words, I can see it being more reasonable, again, considering the audience being Judge Bev, that you can consider that you have enough information now to make a decision that it's okay to say who they were hired from. But I doubt she's going to do it. Again, it would be reasonable to consider it. And therein lies the problem. Okay. In fact, the Commonwealth itself has articulated there's a lack of clarity about key information pertaining to these potential witnesses. If the Commonwealth has been privy to the relevant discovery for months and has had an opportunity to question these witnesses during voir dire in Ms. Reed's first trial, has expressed confusion about the nature of the relationship between ARCCA and the defense, then it is only logical that the jury too might be confused by the nature of ARCCA's involvement. A really good point to be made there. Without a full and complete understanding of how, why, and by whom these individuals were hired. Argument. To avoid unfairly prejudicial speculation, this court should admit the fact that the U.S. Attorney's Office hired and retained employees of ARCCA. Proof of bias or lack thereof directly bears on the credibility of a witness. It is never collateral in nature and extrinsic evidence to prove it is permitted. So what that means is that it's never, because credibility is so important and bias or lack thereof is so important, it's never considered like extrinsic, right? It's always considered like relevant, right? And directly related to the witness. So bias is the relationship between a party and a witness, which might lead the witness to slant unconsciously or otherwise his testimony in favor of or against the party. Bias may be induced by a witness's like, dislike, or fear of a party, or by the witness's self-interest. Proof of bias is almost always relevant because the jury is finder of fact and weigher of credibility has historically been entitled to assess all evidence which might bear on the accuracy and truth of a witness's testimony. And here's the other thing I will say, because I'm thinking to myself, they didn't get into this in the first trial. I think that, first of all, they didn't have time, but they probably could have made a bigger issue about it. I think understandably so, they were expecting an acquittal and that it wouldn't have mattered, right? I think that they were expecting, as did all of us watching, everybody, at least in the Squirrel Crew and myself, that the jury would be like, well, done deal, right? Didn't get hit by a car, done. And I think we were all very shocked when we heard from Ronnie. Thank you, Ronnie, for speaking out. We heard from Ronnie that how they found the opposite, right? Now, again, these were those certain jurors who seemed to be the loudest of the bunch, according to Ronnie, who used that against them, right? And it's potentially a thing where no matter what had been the circumstance, right? If there were strong witnesses for the defense, certain jurors would have found something to say negative about them, right? But I don't think anybody was expecting that. And my thought is that, well, similar to the Lolliport videos, right? Well, they could have made a motion for a mistrial at that juncture, right? When those Lolliport videos came in or something like, not that this would be a motion for mistrial, but as far as the ARCCA dudes go, something that, they should be able to say who they're from. Because I feel like everybody agreed at that point just because they wanted to get them to testify, right? That was the whole thing. It was like, okay, fine. And again, all of those what that has in common is like, they really, I think were sure they were going to get an acquittal, and I don't blame them. And therefore, they didn't make issues out of things at the time because they didn't think it would be necessary. That's my take on it. But see, again, now they have the chance to make these arguments, right? So during the first trial of this matter, the defense was prohibited from mentioning the federal investigation into the investigation of this case. Yep. The investigation extended, however, to the, or sorry, not the investigation. What did it say? The prohibition. There we go. The prohibition extended, however, to the fact that the Department of Justice retained ARCCA, completely controlled the material they were to review and the testing they performed. Okay, so I think this is going to be an important distinction, right? That prohibited from mentioning the federal investigation. That makes sense, right? But there's a separate thing here, which is that the Department of Justice retained ARCCA, right? In other words, that was a further extension of the prohibition. So I think what they might say here is they should be able to say they were retained by the Department of Justice and then leave it at that, right? The jury's not going to hear that and automatically think anything of it, right? It could be retained for literally anything, right? It doesn't have to be for this case. So let's see what they say. So the DOJ retained ARCCA, completely controlled the material. Right. Okay, we read that. To the extent that the Commonwealth impeached these witnesses by pointing out the material they did not review prior to performing their testing and forming their conclusions, the Commonwealth left the impression that the defense improperly withheld certain materials from those witnesses. That was a false impression, and prejudice misreads defense by keeping relevant rehabilitation and credibility evidence from the jury. Worse, the inability of the defense to reveal and or explain ARCCA's initial involvement in this matter led to jury confusion that also prejudiced misread. Post-trial, jurors contacted the parties and or made statements in public about the jury's view of ARCCA's involvement. At least one member of the jury surmised that ARCCA must have been retained by Ms. Reed's insurance company. That assumption would lead to an inference of bias in favor of Ms. Reed where none existed. At least one other member of the jury speculated that ARCCA witnesses were seeking to insert themselves into the case for fame or publicity, like they need it. That assumption would lead to an inference that their testimony should be unfairly discounted. Importantly, identifying explicitly that neither the defense nor an affiliated third party initially hired these ARCCA employees is not only crucial to Ms. Reed's case, but also relevant evidence that is inherently admissible. It is also entirely true, as is the fact that the conclusions of ARCCA witnesses were made before either party was even aware of the existence of the witnesses in any matter pertaining to Ms. Reed. Additionally, there are no permissible grounds under the Massachusetts Rules of Evidence to exclude such relevant and exculpatory evidence, particularly in response to any hypothetical and or unsubstantiated concerns that unfair prejudice or misleading the jury would occur by presenting such information. In fact, presenting to the jury that employees of ARCCA were initially hired by the U.S. Attorney's Office would serve to prevent juror confusion. Absolutely. Yup. Indeed, excluding such relevant exculpatory evidence would mislead the jury. The trier, in fact, in this case, the jury is entitled to hear relevant evidence, particularly that which makes a fact more or less probable than it would be without the evidence. That is the relevancy test. And where such fact of consequence in determining, where such fact is of consequence in determining the action. Knowing that employees of ARCCA were not hired by the defense or Commonwealth and instead were hired at the time they performed their testing by a neutral third party can and should add legitimacy to the credibility of these individuals' testimony, as the potential for bias or any other self-serving reasons for the defense's calling of said witnesses would thereby be eliminated. And we have a footnote. The Commonwealth, of course, is more than welcome to cross-examine these witnesses regarding its allegations of bias or favoritism. This information about the hiring of ARCCA employees, furthermore, could help the jury better evaluate the defense's theory of the case, that Ms. Reed could not have been and was not responsible for the death of Mr. O'Keefe. Essentially, by clarifying who initially identified, hired, retained, and directed the investigation and testing performed by the employees of ARCCA, Ms. Reed should be able to substantiate her lack of culpability by presenting evidence that an impartial third party vis-a-vis their findings corroborates her defense. In short, for the jury to properly weigh the credibility and accuracy of the ARCCA employee's testimony, it must know the full context in which these potential witnesses were brought in to opine on this matter. For these reasons, it is imperative that the jury in this retrial is made aware that the employees of ARCCA were initially hired by the U.S. Attorney's Office, eliminating any possibility that the jury believes that Ms. Reed or any other related affiliates were the impetus for ARCCA's testing and analysis. Footnote 4. Throughout this motion, the defense is referring to the initial retention of ARCCA by the Department of Justice for the purpose of conducting its testing, analysis, and producing a report. The defense again acknowledges that the ARCCA was paid after the conclusion of the first trial, as the defense disclosed in its reciprocal discovery production and was discussed extensively during the motion hearings that we watched over and over again, at least the second one especially. We watched more than once. Okay, the fact that the U.S. Attorney's Office hired and retained employees of ARCCA is relevant, admissible evidence. It is undisputed and relevant evidence that the U.S. Attorney's Office was hired and was responsible for involving employees of ARCCA in an investigation surrounding Mr. O'Keefe's death. This pertinent information that a neutral federal investigative body, as opposed to the defense or an affiliated third party, retained ARCCA is clearly relevant, and beyond being relevant is exculpatory evidence that is fundamental to Ms. Reed's case. And this is just talking about relevancy. We know very well how that goes. Relevant evidence may only be excluded if this honorable court finds that evidence's probative value is substantially outweighed by danger of one or more of the following: unfair prejudice, confusing the issues. Again, we've read this a bazillion times. Acknowledging the objective fact that employees of ARCCA were hired by the U.S. Attorney's Office is relevant, probative, and would not confuse the issues, mislead the jury. Yeah, it does the opposite, right? Or cause, it does, in other words, it's not any of those things. More pertinent to the narrow issue presented in this motion, the probative value of this evidence is certainly not substantially outweighed by any of the above. Relevant evidence by nature is inherently somewhat prejudicial. That's why it is offered. Yep. The rules of evidence have contemplated this fact and bar admission of evidence only if its probative value is substantially outweighed by the risk of unfair prejudice. And they're citing the case law here. Here, the fact that neutral third-party experts hired by the U.S. Attorney's Office corroborate Ms. Reed's fundamental defense that Mr. O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to her SUV consistent with colliding with Mr. O'Keefe, is inherently central and foundational to the fair adjudication of this case. Additionally, the Commonwealth has faced no unfair prejudice. The Commonwealth had the opportunity to cross-examine ARCCA experts during voir dire in Ms. Reed's trial, and notably, the Commonwealth is privy to the testimony of ARCCA employees in Ms. Reed's first trial. Additionally, the Commonwealth has access to the same discovery that the defense has received regarding these employees. Thus, there is no legitimate basis for the Commonwealth to even allege that providing information about the U.S. Attorney's Office hiring of ARCCA would be even remotely prejudicial. The defense acknowledges that this is an unusual circumstance and accordingly an unusual motion in an unusual case. Generally, witnesses who are employed by the federal government testify on behalf of the Commonwealth. Yeah. And defense counsel is unaware of any case in which a defendant has moved to preclude reference to a federal employer. Wow. Of a witness testifying on behalf of the Commonwealth. Wow. It is not uncommon for the Commonwealth to present witnesses employed by the federal government. Yeah. Especially through, though not exclusively, in matters that involve a joint investigation by state and federal authorities. And then they're citing some case law there. The FBI. Undersigned counsel is unaware of any case in which a defendant has successfully argued that eliciting the fact that a witness was employed or contracted by the federal government was improper, let alone caused her prejudice. Ms. Reed suggests that the preclusion of any reference to the party that had retained ARCCA during her first trial caused juror confusion and caused jurors to speculate about who hired the company, prejudicing her defense by reducing the import. I think what's going to have to happen here, that's going to be important. The only way that we know this, or that they know this, right, is because of Ronnie speaking out. I totally agree that, okay, if Judge Bev heard what Ronnie said, right, and believes it to be credible, like, in other words, that how the jurors viewed the ARCCA dudes because they didn't know who hired them, there's no way around it, right, that it caused that. You cannot allow that. You have to say who hired them. Like, that's clear. So I wonder if the issue here that the defense might have will be Judge Bev having not heard that statement, or saying it wasn't under oath. There wasn't, it might be, do we need an affidavit? You know what I mean? And Ronnie said he'd be willing to help. He said it in both interviews. He said, how can I help? I want to do anything I can to help. And I think what would be helpful here is for him to provide an affidavit. Now, the only problem is that he wasn't really representing his own interpretation of the ARCCA dudes, but he was representing what the other jurors said, or what their interpretation was, or assessment. So that's where it still could get a little bit tricky, perhaps, because it's like, well, then we might need affidavits from those particular jurors, right? And that, they can't require that, right? It's different because Ronnie offered to help, and this could be one way he could help. I don't know. We'll see what else they say in here, but this is such a critical issue that if it looks like Judge Bev is going to deny this, then I would 100%, I don't think they can contact Ronnie outright and ask for that. But I think Ronnie could contact them and offer to do it. But this is really crucial, right? And if having something to support, because again, viewing this is how Judge Bev might do it, right? How she might read it, right? Like she's going to try to find every single thing she can to deny it, I would imagine. So it might come down to, we need, a sworn statement about how the jurors interpreted this. Because again, if you can prove that, she's going to have a much harder time denying this, right? Okay. So providing the jury with information about the underlying nature of ARCCA's involvement surrounding Ms. Reed's case, furthermore, would certainly not cause undue delay, waste time, or be cumulative of other evidence. Such information could and would be elicited with a few questions during the direct examination of these potential witnesses, and by no means would be asking the ARCCA employees by whom they were hired and retained to stall proceedings in a wasteful or cumulative way. Questioning on this matter would be brief and could not be entered into evidence but through direct examination. More importantly, perhaps this pertinent evidence would not confuse the jury. In fact, clarifying how, and when they say perhaps, let me just read this again with a different inflection. Most importantly, perhaps, this pertinent evidence would not confuse the jury. In fact, clarifying how ARCCA employees became involved in the investigation surrounding Ms. Reed's case would only mitigate potential jury confusion as discussed above. Again, and that is exactly why I just said what I said about the affidavits. Shout out to MCAT who's listening from work. Love it. Love that you're listening, sneaking a listen in at work. And actually I meant to do this command this way. Okay. Relatedly, for example, in Ms. Reed's first trial, the defense asked during direct examination whether ARCCA employees were hired by the defense or the Commonwealth. The testifying witnesses both answered in the negative. Because further specific questioning about how these ARCCA employees became involved in the investigation surrounding Ms. Reed's case was not permitted, though, the jury was left to speculate, theorizing erroneously that a third party, such as Ms. Reed's insurance company, was responsible for involving ARCCA in this matter. Such an inference by the jury, even if logical, is patently inaccurate. Moreover, the jury should not have to resort to filling in unclear gaps by hypothesizing about the relationship between ARCCA and Ms. Reed, as that allows for facts certainly not rooted in truth and an evidence to influence the jury's perception of key witnesses. This speculation was not cured by the court's instructions to the jury during the first trial. Nope. And is unlikely to be remedied by any instruction in Ms. Reed's retrial, footnote 5. Okay, model jury instruction. Function of the jury. What is evidence? Credibility of witnesses. Picture in your minds that all of it. Okay, this is giving examples of how the judge can instruct the jury on the credibility of witnesses. Okay. Where was that footnote? Footnote 5. Okay, there it is. Okay. Simply providing the jury with accurate information about who involved the ARCCA employees in this matter. I almost said ARCCA dudes, as if it's supposed to say that. In this matter would eliminate juror confusion and, more importantly, would prevent jurors from speculating about what third party hired and retained these individuals. Also, shout out to Gwen, who's also joining us from work. Love it. Love, love, love it. For anyone who missed it at the beginning of the stream, this should also redirect into the newly released Bridge Guy video, unedited, the original. Okay, Ms. Reed has a constitutional right to present exculpatory evidence. Yeah, obviously, right? I don't even know that we need to even go through it. Let's see here. It's manifestly exculpatory. Yep. The Commonwealth cannot in good faith cite legal authority in support of its request for this honorable court to exclude exculpatory information about the hiring of ARCCA employees. So in other words, there's a second level here. Obviously, the results of their testing is exculpatory, but additionally, they're saying that the way they were hired and by whom they were hired is also exculpatory, and the Commonwealth cannot ask for exculpatory evidence to be excluded. That's what they're saying. And Dr. Rentschler specifically were hired by the U.S. Attorney's Office to conduct an independent inquiry into whether Mr. O'Keefe died because of a collision with Ms. Reed's SUV. Resoundingly, these expert witnesses answered in the negative. Mr. O'Keefe neither died as a result of the collision. Yeah, and they already said that earlier. This conclusion made by a neutral third party not engaged by the defense to perform testing affirms Ms. Reed's defense. And what's interesting is when all this shit was coming out about the invoice, literally one of the things that I pointed out was that it seems like the defense was maybe being careful as to how they phrased things so that they had you could call it a plausible deniability, but it's semantics essentially, right? That hired for testing, right, is different than being hired for testimony, and that when they were talking about not being hired, without they didn't specifically say what at the first trial, but like that they could have understood that to mean testing, because they weren't hired for the testing, right? So MCAT says, fast fact. Great way to control annoying office interrupters. Put earbuds in your ear. That's all, whether listening to something or not. Yep. Love it. Glad you're listening to our coverage here, though. This is one of the most important motions in limine, I think, probably that thus far for the defense. I mean, there's been so many, but like, obviously, right? Obviously, the ARCCA dudes were the most important witnesses, and considering the jury completely misconstrued the third party hiring them, I would not have thought this would be necessary, but we know now that it is necessary. So, okay, so it could serve as the most reliable, relevant, and exculpatory evidence in her forthcoming trial. Exclusion of this evidence would materially prejudice Ms. Reed's defense. Here, however, any prejudicial effect runs entirely in the opposite direction. To exclude this pertinent evidence about the U.S. attorney's hiring of ARCCA would result in the jury deliberating with needlessly incomplete information. Ms. Reed's likely most exculpatory witnesses, given that individuals were hired without bias or undue influence by a third party as part of a federal investigation, would only serve to invite jury confusion and cause unfair prejudice to the defense, contrary to the rules of evidence and fundamental constitutional principles of a defendant's right to present exculpatory witnesses. More specifically, the fact that a neutral third party substantiates Ms. Reed's core defense and completely undermines the Commonwealth's theory of the case, is inherently exculpatory. The only thing is this. While that is true, it does undermine their theory of the case. It is inherently exculpatory. The only thing I would worry about is because, again, knowing your audience, Judge Bev reading it, it's almost like she shouldn't view it this way, right? Like she should be like, yeah, it's exculpatory, should come in. I could see Judge Bev reading this, and when she gets to this part about undermining Commonwealth's theory of the case, I could see her denying this because of that, right? Because she's so Commonwealth leaning, right? You know what I mean? Like, in other words, pointing that out, while normally would be important, I don't know if that, I just don't know. I just worry, right? Although surely she must know that without it being said, but still. Considering Massachusetts precedent, it is permissible, particularly during closing argument, to disclose by whom an expert was retained. In fact, a plethora of Massachusetts federal case law confirms as much. Yep, agree, sadly. Yep. Yeah. I mean, it's almost like, even though it'd be tough to argue, it'd almost be better to be like, yeah, it totally helps the Commonwealth case, right? And then, then she'd let it in. And now there's a fuck ton of case law here about closing arguments. So finally, Ms. Reed's constitutional right to present exculpatory information includes inserting a Bowden defense. While both the Commonwealth and defense have long had access to ARCCA employees' findings regarding the death of Mr. O'Keefe, which resoundingly point to an inadequate investigation and a third-party culprit. Oh, okay, ruh-roh. Given the ARCCA employees have testified under oath, I don't think, I would not involve that here. It's not necessary, right? I would not involve that here, especially because there is another motion in limine that we will get to about the third-party culprit defense. And we all know how that seemed, seems so risky, right? To involve that with the ARCCA dudes. Like, leave it be, dude. I don't like that part. I don't like it. I don't like that at all. Okay, but let me keep reading. Third-party culprit. Given that ARCCA employees have testified under oath that Mr. O'Keefe's death was not a result of injuries from Ms. Reed's SUV. Oh, wait, I have that other page on a separate thing. Hold on. Wait, where is it? Okay, I just have to, it is, here it is. The thing is this, I have to share this to you guys. These documents are difficult. So it's just, I have this pulled up in a separate thing. Hold on. Let me share this to you guys. So in other words, there's two of these motions where I have one page from each motion in a separate thing, because that's just how it ended up being. So here it is. This is the page right here. Okay. This is the last page of this motion. Okay, since the Commonwealth had access to this information, did not properly inquire of or investigate other potential suspects, Ms. Reed must be able to present evidence that law enforcement failed to pursue other avenues. As a result, Ms. Reed should be permitted to provide the pertinent information regarding the circumstances of ARCCA's involvement in the case, which led to their ultimate conclusion that Ms. Reed was not responsible for Mr. O'Keefe's death, because such information provided by a third party is crucial to bolstering her foundational defense that the police investigation of this matter was wholly inadequate and that authorities failed to investigate alternative suspects. And it's ending it that way. I'm not a fan of, I don't know. I personally don't think that's necessary, and I wouldn't give her any further reason to try to, further reason as in addition to her own bias to deny it. But okay, so now let me go back to the other one here. Okay. So up next, we have another Commonwealth motion here. Okay, so Commonwealth's motion to eliminate to prohibit reference to any pending internal affairs investigations. Oh boy. Sustained findings unrelated to this case or unfounded allegations of misconduct. Unfounded. Really? Really though? Fuck. I mean, look at these. These were just back to back the way that I have them. I mean, it's insane, right? Like, this case is wild. We have the defense having to fight to get these expert witnesses in that were brought in from the DOJ because the jury interpreted them completely incorrectly and fighting for the dude. And then we have the Commonwealth fighting to say, hey, the fact that all of the law enforcement involved in this case, for the most part, at least the top ranking officers and the lead detective, dude, it's just insane, right? It's insane. It's insane. I am excited to read this. If Judge Bev grants this, I don't know that I'll be able to watch the trial, to be honest with you guys. That might be too much for me. Might be too much for me if Judge Bev grants this. Because literally, this is fair game in every case where you've got issues with officers. I mean, never have I watched a trial where there's been issues as bad as these, right? It's normally like some minor disciplinary action or whatever, but it's always admissible. Same as with any other witness, right? Or any other expert witness or whatever. When they've got something that besmirches their record, but especially here, okay, let me read it before I just start goading to high heaven and beyond. All right. Right. The Commonwealth moves in limine, I'm just shaking my head, to prohibit disclosure or reference to any internal affairs investigations pending against law enforcement witnesses. I swear, I'm gonna have to get this goat ready to go here. Okay. The Commonwealth further moves in limine to prohibit disclosure or reference to any internal affairs investigations with sustained findings, as they bear no relevance, nor do the findings. Oh my God, I'm gonna lose my mind. Nor do the findings relate to any bias exhibited by those against whom the findings have been made. Internal affairs investigations are confidential, and disclosure of any investigations that have not resulted in a sustained finding of misconduct would serve no purpose other than to risk materially prejudicing the proceedings or confusing the jury. Moreover, the Commonwealth moves to prohibit reference to any civil lawsuits filed against Canton Police Sergeant Link relating to an incident that occurred nearly 20 years ago. I don't even know what that's in reference to. Do you guys? In the federal lawsuit previously relied upon by the defendant, there were no adverse credibility determinations against Sergeant Link or any findings of credibility or liability. I wonder if this was discussed. I wonder if this was in a pretrial motion before the first trial, which I didn't cover, and that might be why I don't know about it. The case was dismissed by agreement of the parties. Citing some case law there. Pursuant to Graham B., District Attorney for Hampton District, if a police officer's credibility is a critical issue at trial, the judge has the discretion, in the interest of justice, to admit evidence of specific instances of the officer's false statements in prior unrelated matters. A judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, may consider the age of the prior misconduct, the strength of the evidence of the misconduct, and the simplicity of establishing it, and whether the prior misconduct is probative of how the officer conducts police. Now, here's what I will say. If this is referencing from the previous page, some civil lawsuit from 20 years ago, fine. But that isn't. And maybe that's what they were trying to get in the first trial, right? However, I don't think that is, I mean, I don't know what it is, but I guarantee you the defense would be fine with leaving that out I would imagine that what is more important to the defense is the recent issues, right? So I'm not going to lose my mind just yet because they might be talking about that other thing, which fine, right? Because the age of the prior misconduct, right? Fine. In instances where there have been no sustained findings of misconduct, the jury should not be permitted to consider any allegations of misconduct, whereas also, I just side note, Sergeant Lank is like clearly not the issue here, right? Like, got bigger fish to fry. Fucking hell. Oh, okay. Disciplinary action is one possible. Okay, whatever. In instances where sustained findings have been issued, I want to see what they say about Trooper Proctor and his cohorts. In instances where sustained findings have been issued, which do not reflect untruthfulness on behalf of the officer, nor exhibit any bias against the defendant by the officer against whom sustained findings have been made, the conduct is equally inadmissible and lacks relevance. Further, the Commonwealth requests advance notice and production of any reciprocal discovery related to any specific instances of prior misconduct or false statements that the defendant seeks to introduce or are used to impeach any law enforcement. You guys already have that. Like, that's the end of it. So hold on. Wait, what? Hold on. Is that it? Yeah, it's only 2 pages. So they only are citing, hold on. Let's just be sure. No. It's everything. Hold on. Let's just make sure that let's just make sure what they're referencing here. Fucking hell. Okay. Nope, it's all of it. It's all of it. All right. Go time. It's not just a civil lawsuit from 20 years ago that they're asking for. The Commonwealth moves in limine, so any reference to any internal affairs investigations pending or any disclosure or reference to any internal affairs investigations with sustained findings. I mean, in other words, they already found things. If they're pending, maybe I can see, because that's almost like, it's like there's not been a verdict, if you will. Maybe, right? But when they already have sustained findings, you've got to be fucking kidding me. They bear no relevance. Are you kidding me? Internal affairs investigations are confidential. And any investigations that have not resulted in a sustained finding of misconduct. Well, right. If there's been a sustained finding of misconduct, yes. If there's been sustained findings of misconduct, which I by this point, I believe there has been, and Judge Bev says that can't come in. Nope. Can't do it. I cannot handle that. I agree. I do to a certain extent agree that when they're pending, because like even during the first trial, I think that was the case, right? That there were, now they got worse since, but in the first trial, there was already some investigations going on, but they were pending. When they've already finished it or they've already made findings and they have found misconduct, like conclusionally, I'm losing my mind. Like conclusively, that's the word. Oh my God. So this part is just in addition, the stupid civil lawsuit from 20 years. Who gives a shit, dude? That is not the thing here. I mean, again, I don't know what the lawsuit is, but I would be hard pressed to think that whatever it is, it's worse than this shit in the first paragraph, right? I can't imagine there's anything worse. Welcome, Meg. Glad you're back. Oh, right. Okay. I do remember that now that you mention it. Thank you, MCAT. I do remember that. He stepped in off duty to help Chris Albert. Whatever. If it's about a compromise, right? And the defense is like if I were the defense and it's like the only way to get this in is to compromise, even though they shouldn't have to, my compromise would be fine. We'll leave that part out with the stepping in to help a fight when 20 years, fine. But for fuck's sake, the internal affairs with the people, like, no. That you guys see what I mean? That's a trade-off I would totally make. I would not try to fight for the Chris Albert drunk thing from 20 years ago and risk all of it being kept out, if that makes sense. Ooh, oh my God. And I don't doubt that. I'm sure he's scum, but I'm telling you, like, the Garino and Trooper Proctor and Buchanan and what's the other dude? Tolley, all them. That's I think far more important if they have to make a trade-off there. And maybe they won't have to, but that's wishful thinking. It's Judge Bev, right? Dude, I keep saying, and I'm just going to keep reiterating, you have to know who your audience is, right? And if you're the defense, I would imagine if there's things that are really important, you have to have a plan B and have already talked about and figured out what are you going to be willing to compromise on so that something isn't just entirely shut down. That's what I would be thinking. Oh my God. Okay. Meg, did you see that we're going to redirect here shortly into the Delphi video, by the way? Oh my God. Okay. So we already read the Commonwealth's motion for attorney for juror voir dire. And remember when I was like, oh, I wonder what the differences are. So now here, the defense also has a motion in limine. Both parties want voir dire for the jurors. Okay, so let's just see what else this says. For attorney conducted panel for voir dire of the jury veneer. Now, if you're in the low country of South Carolina, like Poot, you might say venery. Hang on. Let's have a little Poot surprise just for funsies. Okay, so veneer, in order to determine whether such potential juror stands indifferent. And that's funny, they're also using the word indifferent. Because I was like, it's weird that it's indifferent and not unbiased, but maybe that's the words they use in Massachusetts. Ms. Reed requests that defense counsel be permitted to conduct panel voir dire of the jury veneer on the following subjects. Okay, so I think what will be the difference here potentially is the subjects that they're asking for. So here, previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved or have close friends or family who've been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in motor vehicle crash. Yeah, the Commonwealth did not ask for any of this. Whether prospective jurors have been the victim of any violent crimes, and whether prospective, let me guess, jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. And then she reserves the right to ask a follow-up question. Yeah, MCAT says they're all awful, but agree about the trade-off. Yeah, because I mean, it's like if it's that or nothing, you know what I mean? You know, they all say that how do you know it's a compromise? Like a compromise is when let me just clarify. This is as in regards to the law, right? Like negotiations and what maybe like a settlement, right? So a compromise when it comes to the law is you know it's fair when both parties walk away slightly unhappy, right? So okay, argument. So per the rules, the Superior Court is required to permit the requested attorney conducted voir dire. Part of the Sixth Amendment right. Prior to 2014, there was no right to, oh my God. Why does that, I mean, I'm shocked, but now I'm like, well, that shouldn't surprise me because Massachusetts, don't ever go there, guys. Not safe. Before 2014, they couldn't conduct voir dire. You gotta be kidding me. What? That's insane. That is insane. Prior to 2014, there was no right to attorney conducted voir dire in Massachusetts, and whether to permit attorney conducted voir dire in any given case was entirely within discussion of the trial court judges. Love that, not. How much do we trust the trial court judges in Massachusetts, guys? Ugh. Let's all remember that Judge Bev was appointed to this case because whoever the first person was conflicted out. She was the better option. Okay. So, all right. However, in an effort to better protect the right to an impartial jury in an ultimately a fair trial, the Massachusetts legislature amended it. Through that amendment, the legislature created a right to attorney conducted voir dire. The current version of the statute so amended states that, in addition to whatever jury voir dire of the jury veneer is conducted by the court shall permit, upon the request of any party's attorney or a self-represented party, the party's attorney or self-represented party, to conduct an oral examination of the prospective jurors at the discretion of the court. Fucking hell, why is it at her discretion? That's the problem. Problem is the discretion that she has. Let me just make sure that I'm not missing a page. Okay. I tried to actually make a video for you guys of the process of obtaining these, but it wouldn't let me do a screen recording for some reason of my folder. I wanted to show you guys the steps that I have to take to get these documents and present them. But yeah, it wouldn't let me take a screen recording. I guess I could try to film it with my phone. Maybe I'll do that for the next batch because it's crazy. It's really crazy. It's not like other cases. Anyway, okay. The Massachusetts Supreme Judicial Court has interpreted this most recent version of the statute as creating a right to attorney conducted voir dire. A right. So that's good. That kind of takes it out of the hands of the trial court having discretion. Accordingly, it has expressly stated that trial judges must permit, thank God, hallelujah, must permit attorney-conducted voir dire upon request. Thank God for that. Accordingly, because this request for attorney-conducted voir dire was properly and timely made, footnote 1, as per the rule, on or before the final trial conference in a civil case or final pretrial conference in a criminal case, or 5 business days before trial if no such conference is scheduled, the parties shall submit in writing any request for attorney-party voir dire, motions in limine concerning the method of jury selection, proposed subject matters or questions for inquiry by the parties or trial judge, any proposed supplemental questionnaire, any proposed preliminary legal instructions to the veneer or juror panels, the location within the courtroom where jurors and parties will stand or sit during the voir dire, and any other matter setting forth the parties' position regarding impanelment. So they're saying we comply with the rule. The court is required to permit attorney conduct. Okay, so they're saying, hey, look, here's the history of the statute. Initially, it wasn't allowed before 2014. Then in 2014, it was allowed, but the trial court had discretion. And now they're saying most recently, the case law is showing, hey, Judge Bev, it's not up to your discretion. You have to allow it so long as the request was made timely as it was here. So they're showing her she has no grounds on which to deny this. And again, I don't know if this was done in the first trial or not because I wasn't following it. But I would certainly hope so, right? All questions proposed by defense counsel are consistent with the guidance in Superior Court Rule 6 and necessary to ensure Ms. Reed's Sixth Amendment right and should be allowed. While trial court judges must grant attorney-conducted voir dire when properly and timely requested, judges retain discretion over the scope of attorney-conducted voir dire. The scope, but not whether or not it's allowed. Important difference there. So the rule, so they're going through that and precludes attorneys from asking a small number of questions on particular subjects. Where's the footnote on that one? As per the rule, counsels and parties may not ask, questions framed in terms of how the juror would decide this case pre-judgment, including hypotheticals that are close or specific to the facts of this case. Any hypotheticals that may trigger this rule must be presented to the judge before trial. 2, questions that seek to commit jurors to a result, including without limitation, questions about what evidence would cause the jurors to find for the attorney's client or the party. So in other words, they can't say, hey, if you had 2 ARCCA dudes come in here and say, nope, not hit by a car, right? You as an example, right? You can't ask questions about evidence that would cause them to reach a specific finding, right? Number 3, questions having no substantial purpose other than to argue an attorney's or party's case or indoctrinate any jurors. Number 4, questions about the outcome in prior cases where the person has served as a juror, including prior votes of the juror or the verdict of the entire jury. So in other words, they always ask, have you served on a jury, but they cannot ask about the verdict or whatever, things, how the jury discussed things or deliberated. And then number 5, questions in the presence of other jurors that specifically reference what is written on a particular juror's confidential juror. And so this was brought up earlier, right? About there can sometimes be confidential matters. They can't ask about that in front of the other jurors, which makes sense. And then we'll go ahead and read this other rule here. So footnote 3, specifically, defense counsel seeks to inquire of the jury whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating. And actually they already referenced that on the previous page. So, okay, I can zoom out a little bit more here. So now we'll go back to where that footnote was. Okay, so, right, a small number of questions on particular subjects that they can't ask. We just read that footnote. Critically, though, Rule 6 also includes guidance that the judge should generally approve a reasonable number of questions intended to reach certain permissible ends or inquire into certain relevant topics. These questions include 1, so this is permissible, seek factual information about the respective juror's background and experience pertinent to the issues expected to arise in the case. 2, they may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise in the case. 3, inquire into the prospective juror's willingness and ability to accept and apply pertinent legal principles as instructed. 4, are meant to elicit information on subjects that controlling authority has identified as preferred subjects of inquiry, even if not absolutely required. Rule 6 also explicitly instructs that in so doing, judges should consider the goals outlined in Rule 6.1, which includes permitting parties and their attorneys to participate in the process of identifying potential juror biases, and then citing the rule there. The subjects that defense counsel has proposed for attorney-conducted voir dire are subjects into which Rule 6 instructs inquiry should be allowed. Most of the proposed voir dire subjects, which we just read at that footnote, will aid defense counsel in evaluating prospective jurors' ability to be impartial by eliciting specific evidence of relevant biases, such as bias in favor of police officers or against people who are accused of operating a motor vehicle under the influence of alcohol. Consequently, questions on these subjects should be allowed as questions that, quote, seek factual information about the prospective juror's background and experience pertinent to the issues expected to arise in the case, and may reveal preconceptions or biases relating to the identity of the parties or nature of the claims or issues expected to arise in the case. With respect to the proposed questions on the subject of the bias due to media attention, in particular, Massachusetts courts have recognized the potential biasing effect of extensive pretrial media coverage of a case, and then citing more case law there. Similarly, wait, where was I reading? Okay, sorry. Ms. Reed's case has been highly publicized both in Massachusetts and nationally. Since this criminal case began, newspapers and news network, including a bunch of these people, to name a few, have been covering Ms. Reed's criminal case, some publishing about the case repeatedly over the course of months. There's a footnote. Okay, this is citing all these different articles and shit, right? Okay. Given the significant media coverage of this case and the resulting likelihood that many potential jurors will have learned information about the case through the news, it will be particularly difficult to impanel an unbiased jury for Ms. Reed's second trial. As such, allowing defense counsel to question the jurors on subject of media attention of the case has garnered, sorry, let me read that again. As such, allowing defense counsel to question jurors on the subject of media attention the case has garnered is necessary to ensure the impartiality that Ms. Reed is constitutionally entitled to. Questions on the remaining proposed subject of whether prospective jurors' understanding can be impartial in the light of procedural protections afforded to defendants in criminal trials should be allowed as inquiries into prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed. Okay, and then remember how I said there's another motion where I have a separate page on a separate thing? This is the one. Okay, so let me stop sharing. It's the last page of this motion. So that's funny. Okay, here it is. I had it on a separate thing again. If I can make that video to show you guys what you have to do to get these documents and present them, then you'll understand why this was the way it was. Okay. So Rule 6.3c thus affirmatively counsels that each defense counsel's proposed voir dire request or subject should be allowed. Ensuring Ms. Reed's constitutional rights to an impartial jury requires allowing inquiry into the proposed subjects. Allowing defense counsel to inquire into proposed subjects not only complies with the rule, but is also necessary to protect Ms. Reed's right under the Sixth Amendment of the U.S. Constitution to an impartial jury, which hinges in part on adequate voir dire. In this case, adequate voir dire requires not only that this court follow the Supreme Judicial Court mandate to grant a timely and proper motion for attorney-conducted voir dire, but also that the court allow attorney-conducted questioning on proposed subjects that meaningfully aid in the identification of unqualified jurors. Citing the case law here and also the rule. Identifying bias, given that defense counsel's proposed questions contravene no part of Rule 6, fall within the type of question which Rule 6 counsels should be allowed in reasonable number and are necessary to ensure adequate voir dire and thus Ms. Reed's constitutional right to an impartial jury, this court should permit defense counsel to inquire into all subjects included in its proposed jury questionnaire. And now I just have to go unshare, reshare one last time, guys, for this last page. So we can close the loop on this document here. All right. Conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court grant her motion for attorney-conducted panel voir dire of the jury venire. So with that, what we're going to do is this should, fingers crossed, automatically redirect you guys into the Bridge Guy video. And for those of you guys who haven't seen it, it is substantially different from anything that we had seen before. And I'm sure there's probably people at that live stream waiting with bated breath for us to get started. So also just real quick, we should have some more streams coming up today. Potentially more for Karen Reed, potentially more for Idaho. I'm just gonna have to look and see which one has more documents coming out from where we left off. And then also we're gonna do tonight the Lori Vallow hearing where she represented herself pro se and argued exceptions to the hearsay rule. But I love all of you guys. Thanks for being here. And with that, I'll go ahead and roll the outro and I will hopefully see you guys over yonder through the magic of technology. And if not then hopefully on another stream later today. But love you guys and squirrel out.